Could everyone please stand as I read our judgment in this case? Whereas home care workers in California provide essential services that protect the independence, dignity, and well-being of seniors and persons with disabilities, and whereas home care workers fall into many categories, for example, paid and unpaid family caregivers, personal care attendants employed through publicly funded programs, home care aides employed by private agencies, or attendants serving private pay clients. And whereas home care workers across the state have joined together to demand increased dignity and respect and equal rights under the law, and whereas consideration given to home care workers under federal and state laws has historically reflected stereotypical assumptions about the nature of such work, specifically that employment within a household was not real, productive work, and that women did not work to support their families. And whereas the majority of home care workers are women, low income, and of diverse ethnic and racial backgrounds, and whereas the average wage rate for workers providing services through California's in-home supportive services program is $10 per hour with no paid time off or retirement benefit, and whereas in 2014, workers providing services through IHSS were specifically excluded from legislation granting paid sick leave to nearly every worker in the state. And whereas a recent federal court ruling has denied home care workers across the nation from being eligible for minimum wage and overtime protections under the Federal Fair Labor Standards Act, and whereas IHSS workers who are the parent or spouse of the consumer for whom they provide care do not qualify for Federal Insurance Contributions Act deductions due to exceptions in the Federal Internal Revenue Code, and as a result are not eligible to receive Social Security or Medicare benefits upon their retirement. And whereas exclusion from these basic labor protections has contributed to the poverty, financial hardship, reliance on public benefits, and the disempowerment of home care workers. And whereas since 2009, the IHSS program has once again been the target of massive budget cuts, enduring repeated legislative attempts to reduce clients' access to services and workers' hourly wages. And whereas IHSS currently suffer an ongoing 7% across the board cut to services and hours, and whereas low wage and meager benefits drive many workers out of these important jobs at a time when the need for home care workers in California is expected to dramatically increase as a result of the aging of the baby boomer generation. And whereas improving the wages and benefits of home care workers has been shown to improve the economic well-being of workers and their families, substantially reduce industry turnover, and improve access to reliable and quality services. And whereas the current IHSS collective bargaining environment in California has not adequately elevated industry wages and benefits, with workers being denied pay increases for many years. Whereas IHSS is the nation's largest publicly funded non-medical program designed to ensure that seniors and people with disabilities are able to live independently in their own homes. And whereas IHSS is the foundation of California's efforts to comply with the 1999 U.S. Supreme Court Olmstead decision, which requires public agencies to provide services in an integrated setting. And whereas IHSS saves California and the federal government billions of dollars by preventing unnecessary hospitalization and institutionalization, therefore, be it resolved that home care workers and clients in California have faced numerous violations of their rights, including the right to equal treatment under the law, the right to needed in-home supports and services, the right to Social Security, the right to favorable working conditions, the right to paid time off, the right to retire with dignity, the right to a living wage with benefits, the right to workman's compensation, the right to freedom from injury and violence on the job, and the right to privacy, their own bed and lockers for their belongings. Be it further resolved that both the state and federal government should take immediate steps to extend basic labor protections to all home care workers, and be it further resolved that both state and federal governments should increase funding for long-term supports and services like IHSS, which allow individuals to remain safe and independent in their homes and communities. And be it further resolved that California should restore the ongoing 7% cut to service hours for IHSS clients. And be it further resolved that the California Domestic Worker Bill of Rights, currently set to sunset in 2016, be made permanent and expanded beyond overtime pay to include labor rights equal to those of other workers. Be it further resolved that California pass legislation to transition collective bargaining in IHSS from the county to the state level to allow workers a better chance to secure a living wage and benefits. And be it further resolved that California should move forward with implementing overtime pay and other labor protections for IHSS workers without, hear me now, without compromising or reducing any hours of support for IHSS consumers. We urge the state to ensure that in circumstances in which relatives provide IHSS support to 2 or more family members, in which a person receives a waiver personal care services in addition to IHSS, these consumers continue to get all the services they need from their home care worker of choice. And be it finally resolved, on behalf of the Justice for Home Care Tribunal members seated behind me, that achieving equal treatment under state and federal labor laws would be an essential step toward valuing the work of home care workers, as well as a rejection of antiquated and long discredited stereotypes about domestic work. Thank you very much, and congratulations.